of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. Thank you for joining us via video. We will conduct this argument just like we would if you were, if you and we were in the courtroom. If you have any problems, I'm sure that Mr. Hivner can help you. But, I understand everything's ironed out and good. So, Mr. Hivner, would you call the first case, please?
Manchester Hotel Hospitality, LLC, et al. Versus City of Manchester, Tennessee, et al.
Okay. The appellant can go whenever you like.
Thank you, Your Honor. Good morning. May it please the court. My name is Garrett Swartwood. I'm from the Knoxville Bar Association, and I'm representing Manchester Hotel Hospitality, LLC, and Trayson Elm, LLC, which were the plaintiffs in the trial court and the appellants before this court. And I'd like to reserve 4 minutes for rebuttal argument, which I think has already been included on the clock, Your Honor.
It's been put on the clock.
This case involves the time period in which a party can challenge by a petition for writ of certiorari the decision of a governmental agency. And in this case, it was the Manchester Board of Zoning Appeals, which made a decision to approve a variance request that had been opposed by the plaintiffs. So the plaintiffs filed a petition for a writ of certiorari. That petition originally did not include an oath, and so an amended petition was filed with the oath. Nevertheless, the defendants filed a motion to dismiss, and the court dismissed the case on the notion that the amended petition was not filed within 60 days from the entry of the BZA's decision. So in this case, obviously the issue then is, when did the BZA decision get entered in order to trigger the time period? The relevant time period is set forth in Tennessee Code Annotated 27-9-207, which provides that, 102, which provides that the petitioner challenging this governmental action has 60 days to file the petition from the date of the entry of the order or judgment of the governmental agency. Now, the Tennessee Supreme Court, in the case of Carter versus the city of Nashville, addressed this issue, and it distinguished between the rendering of a decision and the entry of a decision. And I don't think there's any dispute in this case that the rendering of the decision by the BZA, that is the time that it made its decision, is different from the time that the decision was entered into the records of the BZA. So there are several dates that I want to refer to. The record's not very voluminous because this was a case decided on a motion to dismiss. So the relevant dates are September 17 of 2018, and that's when the BZA held a meeting and heard comments in favor and opposition to the variance request, and it held a vote at that time, and it rendered a decision at that time. And there's really no dispute that that's the date that a decision was rendered. It's also not disputed, however, that that was not the date on which the BZA entered its decision. So there are several other dates that the court should consider. Immediately following the meeting on September 18, 2018, according to an affidavit that was submitted by the defendant, the director of the codes department for the city of Manchester apparently placed a check mark on the application for the variance request. The check mark was in a box next to the word approval. And that's the date on which the defendants suggest that the entry of the BZA's decision was made in order to trigger the 60-day time period.
Does
Now, the following-
Mr. Sane date the application when he does the check mark?
No, Your Honor. There's no date. The only dates on the application are the date of the application and the date of the meeting, but the date of the check mark is not dated at all, which raises the question, how could anyone possibly know when the 60-day period of time even begins to run?
And so okay, that's my next question then. What happens to that application after it's been checked by Mr. Sane? Does it go to the file then immediately so someone in the public can inspect this file, or what happens to it at that point?
Well, the only evidence we have is the affidavit of Mr. Sane, who says that the application, I think you mentioned that it is kept with the codes department. And of course, the codes department, he also states, is responsible for issuing a permit. So Mr. Sane has kept the application with the notation that the variance was approved with the codes department, apparently for the purpose of issuing a permit and knowing what sort of permit to issue and whether a permit can be issued with the variance that's allowed. So following that September 18 date, the next important date is October 15 of 2018, in which the BZA itself meets again. Apparently its next monthly meeting. And at that meeting, it approves the meeting minutes from the prior meeting in which the approval was passed. And it's our contention that that is the date that the time period under the statute is triggered. And that position is consistent with this very court's decision just a couple of years ago in a case of Metz versus City of Nashville, where this court said that the time for appealing a planning commission decision starts running when the minutes are signed and entered. Now, there's other cases. There's a case called Grigsby versus City of Plainsview, which suggests that you can't have another date other than when the meeting minutes are issued, provided that that other date is an event where there is enduring evidence of the decision that's entered into the record, some enduring evidence. And the defendants cite to a case called Advanced Sales, in which there was an application, and the application had the word approval on it, or not approval, and the word approval was circled. And so the defendants suggest, well, that's very similar to the check mark that's on the application in this case. However, Advanced Sales has a couple of very distinguishing features to it, or facts to it, one of which is that there was no evidence of when the meeting minutes were approved in that case. And the second one is that in that case, the court noted that that application was not only marked approved, but also signed by the secretary of the BZA. Now, the defendant suggests that that's not really significant. It was just mentioned in passing in the Advanced Sales case. But this court, in a following case, a couple of years later, McMurray Drive, addressed that very same issue. McMurray Drive was a situation where a planning commission had made a decision. A secretary at the meeting had made notes of that decision that were later converted into meeting minutes. And the planning commission took the position that those notes constituted the record, the enduring evidence that started the trigger of the 60-day period. But the court noted that those notes did not contain any signature. They did not contain any signature of the planning commission. And so the court distinguished itself from Advanced Sales, in which there was a signature, which the court described as an authoritative signature. So in our case, if you look at the application itself, there is no signature at all by the codes director. There's no signature by the BZA or by any representative of the BZA. There's no date, as the court notes, for the date of the check mark. There's no way of knowing, if you just look at the application itself, when the entry occurred or who had the authority to enter the entry. And we contend that that can't possibly constitute enduring evidence of the BZA's action. Instead, we have very clear enduring evidence of that action, which was the approval of the meeting minutes. So this case is very similar to the McMurray case, which found as well that it was the meeting minutes that triggered the time period. I want to emphasize for the court the significance of pegging this date on the meeting minutes. The triggering of the statutory period of time to file a petition is very important. It's a very short period of time. The time period governs the subject matter jurisdiction of the trial court. If you file late, the trial court loses its subject matter jurisdiction. So it's a very important event that must constitute this enduring evidence of when the action is entered. In this case,
there's no contention on your part that the first petition that was filed without the oath was valid or stopped the time period or anything like that.
That's correct, Your Honor. We are relying on the second petition that
Okay.
was filed with the oath. That's correct. And that petition was filed within 60 days from the date of the meeting minutes were entered. And we would submit that for that reason, the trial court's decision was erroneous and should be reversed. There are a couple of issues that I'll probably take up in the rebuttal period, assuming counsel touches on them. And one is whether or not the codes director who submitted an affidavit even had authority to enter the BZA action. There's no dispute that he wasn't a member of the BZA. And I would submit to the court that his affidavit does not actually say that he had authority to enter that action. So even if the application itself, even if the court considered that it might be something that can rise to the level of enduring evidence to trigger the 60-day period, we would submit that the codes director didn't have authority to do that. There's no evidence in the record that he did have that authority. There is no evidence that that was the date that triggers the 60-day period, and so the trial court should be reversed.
Thank you. Mr. Ewell.
Yes, Your Honor. Police Court, I represent the City of Manchester and its Board of Zoning Appeals and the members thereof. I think finally we got down to what the real rub in this case is whether the form completed by Mr. Sain is the enduring evidence of the board's decision. As stated in their statement of facts and as conceded today, there's no dispute that what Mr. Sain put on the form and how he completed it was entry of the decision made by the board on September 17, 2018. The question is whether that, there's no question that was the accurate rendition of the judgment that Mr. Sain did it, that was what the board did on September 17, 2018. The issue now raised is whether it's the enduring evidence to trigger the time period for the filing of the writ of certiorari. As indicated, I cited the advanced sales, which is almost identical to this. I know that there was an allusion to Mr. Sain's authority to enter the board's decision at the end of Mr. Swartwood's argument. I would point out to the court that this was not raised by the appellants in the trial court until the motion to alter or amend the court's ruling. In the initial response to the motion to dismiss that I filed in response to the amended petition, they did not raise Mr. Sain's authority. His affidavit was in the file as part of my motion to dismiss, and it states that he is the custodian of the records, that he enters the board's decision, and that this is the board's decision, and that simply wasn't challenged until the motion to alter or amend, until the appellants had actually lost. So I would assert that issue is waived, but in any event, Mr. Sain's affidavit is that the form that he completed is the permanent records of the City of Manchester. And I think that's where we don't need to lose sight. As Mr. Swartwood said, most of this harkens back to Carter versus City of Nashville. And the term used in all of the opinions is enduring evidence of the board's decision. Mr. Sain's affidavit clearly sets forth that this is the enduring evidence. It's part of the permanent records of the City of Manchester, kept in his office, and the City of Manchester will issue a building permit in response thereto.
Can you look at that enduring evidence of the board's decision and tell when the time starts running?
Yes, if you look at the date of the meeting, because the date of the meeting is on there, and then it's got board action. So the board action would not be at any time other than a meeting. That's correct.
So are you suggesting the time for entry is the date of the board meeting rather than the date he checks the box, which was the day after?
It could be the day after. He says they do it at night, and so sometimes it's the next morning before he treats it. If it was the 18th, I probably would not make the argument. That's true. You can't look at the document and tell. That's correct.
So if you look at the document, you would have to assume it was the 17th.
Correct. And you would be safe in that assumption.
Okay.
And I guess a person wanting to challenge a variance decision would have to know what Mr. Sain's personal habit was in terms of approving to get the extra day.
To get the extra day, some person would have to know that. That's correct.
And is Mr. Sain the only one in the office that does the approval, or do we know that? What happens when Mr. Sain is on vacation?
I have never known him to be on vacation. I think he just comes to these meetings. I think he comes to these meetings and just fixes his vacation to accommodate that. Really, they're just three people that work in there.
I have a lot of respect for planning and codes directors, so that doesn't surprise me. I guess that he doesn't take vacation.
He just takes it at the other 3 weeks of the month, I guess. So. But
at what point can one apply for and receive a building permit?
After the board's action, the next morning. These meetings are at night, and so the next morning they could have walked in and gotten a building permit. Just because the office wasn't open that night after the Board of Zoning Appeals meeting. So the next morning at 7:30, they could have walked in and applied for one.
Okay.
And the issue is, as much as we can talk about it and talk about the other cases that have enduring evidence and things that were or were not, it rises and falls on that document, and I can't make it any different than that. And Mr. Sain's affidavit is that is the permanent record. It's what's in the codes department. Actually, the minutes are not even kept there. The minutes are kept downstairs in the vault. So if somebody wanted to know what the Board of Zoning Appeals did and went to the codes office, this is the document where they find out what happened, because it specifies, and I raised that part in my brief, it specifies and identifies the property that is the subject of the variance and what the variance is on that it was the intended use, and it's got the only detail is provided in the document that's in the codes office. So the enduring evidence,
the minutes aren't that detailed.
Correct. That's correct. It would just be a motion to approve the variance was made by, but it doesn't have the minutes don't have the property, but the document that's the enduring evidence attached to Mr. Sain's affidavit has the zoning, the tax map, all of the items from which you can tell exactly what happened. So we would dispute that the October date is the date that the decision was entered. It's our position that Mr. Sain's unchallenged affidavit, that no one filed a countervailing affidavit. Nobody on behalf of the appellants challenged what Mr. Sain said in his affidavit. In fact, as I mentioned earlier, the statement of facts was what Mr. Sain's affidavit says happened is exactly what they concede happened. They just argued that it doesn't have the legal effect of being the enduring evidence of the board's decision on that day. The city of Manchester would contend that it does, as there is nothing else that gives that. A person could walk in and obtain a copy, get the building permit as was indicated, and the city would assert that is in fact the enduring evidence of what occurred on that day, and triggers the time period for the writ of certiorari. And
So what about his authority to check that box? Mr. Swartwood
that was
challenges that.
right. And I have filed a motion to supplement parts of the Manchester Code. I think he is the de facto officer. In fact, his affidavit, I know Mr. Swartwood challenges that in his brief, but he didn't challenge that in the trial court until after he had lost. The first time Mr. Sain's authority was raised was in the motion to alter or amend filed July 23rd, 2019, after the court had already ruled on June 25th, 2019. The court just simply overruled that motion to alter or amend. So that issue wasn't even raised timely in the trial court. I think Mr. Sain's affidavit states that he enters the decision, and without that being challenged timely, then I think that statement goes, that he had, and after all, we're talking about a ministerial act of entering the decision. He doesn't have the authority to make it. As was pointed out, he's not a member of the board, or he has no authority regarding the making of the decision. He just simply enters it, much like a clerk would enter a decision of any court or any place, and he just does it.
Well, except a clerk would stamp it entered with a date on it.
That's correct. Most of the time, I think that's correct.
So that's how we know when to appeal. Let me follow up, Mr. Ewell, a statement you made about the detail of the minutes. Looking back at the amended petition, and it looks like to me, if this is an accurate quotation from the minutes, that the minutes are actually fairly detailed. It says in paragraph 49 of the amended petition, after much discussion, there was a motion by member Nichols to approve the variance due to lot 7 being created with comfort suites, was developed with the northern side property line placed at an angle and a 30 by 40 utility easement being located on the front of the property. Due to current fire codes, a drive had to be placed on all sides of the building. This required the parking lot layout to change, causing the buffer width to be decreased in some areas. I mean, that sounds pretty detailed to me, actually.
Actually, for what the variance was, it is, but it doesn't tell you the property, the tax map, the zoning, or any of the other stuff that yes, the detail of what the variance was detailed in the minutes, but to what it applied is not apparent there.
Is there a complete copy of the minutes in this record, or is all we have what's quoted from the amended petition?
I could not answer that.
Okay.
But back to the foundational question, it's what constitutes the enduring, the first enduring evidence of what occurred. Because actually, the theory of the motion, or the review by writ of certiorari is to, if you're going to challenge a decision, as he said, you don't have very long to do it. And that's so government action can move forward. And so even though there might be other evidence, enduring evidence of the decision, the measuring part is the first enduring evidence of the board's decision, because the business of government has to get on. And that's why there is a 60-day period. It's not to prolong things. And even if the minutes constituted enduring evidence, the form completed by Mr. Sain also does, and it's the first enduring evidence of what's there as to what measures the time for filing the writ of certiorari. I think we could all certainly concede, argue that there's might be more than one enduring evidence of the board's decision. but that's not where the measuring date begins. It's the first enduring evidence of that decision, and the city would respectfully submit that it is the entry by Mr. Sane of the approval on the form, the meeting date form, that becomes part of the permanent records upon which the Codes Department acts in the future.
One other question. In the approving of the minutes, that's normally done at the next board meeting.
Yes, Your Honor.
And is there situations where that meeting is postponed or canceled at any time? Have that ever occurred?
I cannot tell you from direct knowledge, but I would suspect that it has. I think I've even been to one where they didn't have a quorum and had to, and a meeting got postponed. I don't go to those meetings enough to tell you firsthand knowledge, are they ever postponed or whatever, but I would say without a doubt they are, because it seems like I did in fact go to one time and they didn't have a quorum, and of course they didn't have a meeting without a quorum, and then whatever was done at a subsequent meeting.
Okay, thank you.
Yes, sir.
Any other questions? No? Okay, Mr. Yule, do you have any more you want to say?
No,
Got a
Your
minute.
Honor, I do not. No, I've still got some time, but I have nothing else to say, Your Honor.
All right. Well, thank you. It's nice when someone doesn't use up all their time. It's unusual. Mr. Swartwood, you have 4 minutes for rebuttal. You need to unmute. There you go.
Sorry, Ron, can you hear me now?
Yes.
Thank you. Thank you. I find it difficult to use less than all my time, but I'll try to do that as well if I can reciprocate. So a couple of comments on the affidavit of Mr. Sane. It's very short affidavit. It's 8 paragraphs long. And it doesn't actually say anywhere in there that I have been granted the authority by the BZA to mark this sheet of paper on behalf of the BZA and enter this as the record of the BZA action. It doesn't say that anywhere. It says that in paragraphs 5 and 6 that I, as codes director, enter the board's decision. He says that I entered the board's decision approved, but that's really, and the word enter, of course, is coming from the statute. It's really a conclusory statement as to whether that is the entry of the board's action. He's not stating facts. He's stating a conclusion that he enters the board's action. The facts would have been, I personally, Mr. Sane, marked the application. I hand it to an administrative assistant. I watch her put it into our file. You know, those would have been facts. He's not stating those as facts. He's simply stating that he enters the board's action, which is a conclusory statement, which the court should not regard at all. There's really no evidence in this affidavit, nowhere that he says that I have the authority on behalf of the BZA to mark this document and enter into the records as the record of the BZA.
But
He's
basically, he does say that's the practice.
He says that the practice is that he enters the board's decision. And so once again, the only point where he says that is where he's using this word enter that comes straight from the statute, which has legal significance.
And that's the check mark.
And that's the check mark. That's correct, Your Honor. So as the court has noted, the check mark's not dated, it's not signed. There's no way for anybody who comes and looks at the records from the codes department to look at this application with that check mark and know when their time runs to file a petition.
Does it state on it that it was heard on September 17th?
It does, Your Honor. So it has a meeting
That's
date.
the date one would assume when one looked at the document.
Well, but we know from the Tennessee Supreme Court's decision that date of rendering is not necessarily the date of entry. And
but there's nothing else on the document that would indicate a different date. You would
That's correct, Your
assume-
Honor.
Okay.
That's correct. That's correct. But still, this is as I pointed out, a significant event. The entry of the action of the BZA is a significant event. It controls the subject matter jurisdiction of the court, and it shouldn't be left to doubt. It shouldn't be left ambiguous, and it shouldn't be left to some assumption that we have to file it at least by the meeting date, because we know that's not true. It's not the meeting date itself, but the entry date. And just in my final seconds, Your Honor, Mr. Ewell points out that we didn't raise the qualification of Mr. Sane until on a motion to alter or amend. I would point out that that is before the trial court. That did give the trial court an opportunity to consider that issue. But one issue the trial court did not consider and was never raised in the trial court is this issue of de facto authority. That was something that's been raised for the very first time here on appeal. It was never brought before the trial court's attention. The court should consider that issue waived. The trial court's decision was erroneous, should be reversed, and the case remanded for further proceedings, Your Honor.
Thank you very much. Thanks to both of you. You've presented quite an interesting case. And thank you, Mr. Clerk.
This honorable court is now in recess until 10 a.m.